Welcome to episode number 217 of AAA Weekly Knowledge Series. IBC has completed 10 years and we'll talk about it, whether it is a successful 10 years or otherwise. We will also share what exactly the public is talking about. Last week, we have attended two events where the theme was celebrating 10 years of IBC, celebrating 10 years of NCLT. And all the stakeholders attended these events and spoke many positive and negative achievements of IBC and NCLT. Then we thought that we should also come out with a detailed analysis of what is achieved in the last 10 years as an economy, as a business. So we in fact studied all this. We'll start with various numbers, that what all numbers that we have achieved so far, and that is where we actually will find that the 10 years, what have we achieved. There are criticism also, and we'll try to also agree to some extent with the criticism, but there is a perspective also for those criticism, and we'll talk about it. So Ankit, first of all, in case we try to see the infrastructure which in fact was created, it was kind of lightning speed that the infrastructure was created. When we recall the IBC, the Insolvency and Bankruptcy Code was promulgated on 28th of May 2016. And in the meantime, what has happened in these couple of months, the IBBI was also established and the IPA, 3 IPA was established, then IU was also established, and the various insolvency professionals were also enrolled. Everything started in few months. So that was the lightning speed. So that was the first achievement, that immediately after the promulgation of IBC, the entire infrastructure was created. NCLT was established on 1st June 2016. Although the two things like IBC promulgation, NCLT, everything was almost 2-3 days plus minus. And then on 1st of October, the Insolvency and Bankruptcy Board was also formed. And thereafter, in case we see, on 30th of November 2016, the enrollment of insolvency professionals also started. So this was the first achievement, that it was implemented on lightning speed. The NCLT benches were in fact set up, IBBI office was set up. And in case we see that what we have seen in the last 10 years, in fact, there are almost 9,000 CIRP admitted, 8987, the corporate insolvency resolution process were admitted. And in this admission process, like this much was admitted, however, about 30,000 such applications were also settled pre-admission. Now, this is a biggest contribution to the economy, to the business of this country, that the 30,000 creditors got relief from NCLT. Either their debt was settled before commencement of CIRP, it was paid, or there was a mutual agreement to resolve that kind of debt. 30,000 applications. And I believe, as per the MCA press release, that also involved almost 14 lakh crore of amount which was being claimed by those applicants. Look at this impact on the overall business. Otherwise, this money could have been stuck, and now this money actually came back to the business. Out of all this, 1419 resolution plans were approved. So some people say that out of 8987, only 1419 was resolved. What happened to the others? Why the others were not resolved? So Ankit, at this moment, I think let us understand why the Insolvency and Bankruptcy Code was brought in. What was the difficulties when this was brought in? What was all those sick units which were stuck up in BIFR? Where all those cases which were stuck up in the High Court for winding up or voluntary winding up, those were stuck up. So when all those cases came to IBC, they were all closed. It was all the assets of those companies where there is no business model. So those has to be liquidated. They were waiting for the liquidation. There was no possibility of revival. So in case initially, when we actually took over the legacy of BIFR, we took over the legacy of banks restructuring, RBI restructuring schemes like CDR, SDR, S4A, and various such restructuring schemes. Ankit, everything was in fact stuck up on those things. So all this legacy came when the viability was not there. To the closing a business is also a fundamental right as per the Constitution of India. But that was not available. That was in fact a very tardy process. So this actually made all those cases come to insolvency law. And finally, what we saw that the 3,000 companies were liquidated out of this. 3,000 companies were liquidated and 1,388, in fact, the promoters somehow settled. Even after the CIRP commencement, they settled the debt and they actually came out of the insolvency. And again, in 1,292 cases, it was again withdrawn under Section 12A by the promoter. So this means 1,388 in fact also survived, 1,292 also survived, 1,419 through resolution plan. So in case out of 8,987, only 3,003 companies went to liquidation only because of that past legacy, because these companies were stuck up somewhere in voluntary winding up or in winding up proceedings before High Court or before the SICA before BIFR. So with this intent, when this IBC was promulgated, the basic intent was to give something new to the economy, because this BIFR and the High Court winding up was not functioning as per the expectations of the economy businessmen. Now, Ankit, can you just, I think you have also seen all this, can you just brief our audience what was achieved in BIFR and what was achieved in the winding up proceedings?
So before I go to that, I remember one of the comments which was passed by the former Supreme Court judge who was there at the events that we have just attended. And he talked about how in SICA there was a company for which the matter was taken up, or rather disposed by Supreme Court after 50 years of that company being in SICA. 50 years.
Yeah.
And we have ourselves managed companies where SICA was safeguarding the promoter interest for as much as 30 years.
Yes.
And after that, the assets of that company have actually gone back to being used by the economy or by a promoter to do something better. So I believe that it's very important for us to weigh, or rather compare, the performance of IBC with what it has replaced or what was there before it. And that's very, very important. So when we talk about pre-IBC, we talk about SICA for some time. So this was Sikh Industrial Companies Special Provisions Act. It was enacted in 1985. And this law, which was established, was to rehabilitate Sikh companies. And it said that the mandate given to BIFR was to turn around companies within 6 months or order closure. So again, 6 months and 180 days in IBC are very similar. And what actually happened was that by March 1991, 1,020 cases were registered, only 182 revival plans were sanctioned, and 120 were recommended for winding up. Everything else which was there before this forum was pending, and it was stuck in a timeless limbo where the creditors were made toothless because the protection to the debtors was given. The companies continue to be under the management of the former promoters, and therefore it became a difficulty for those companies to survive, because one, the promoters were milking those companies for the time period when it was in their control, and secondly, they were doing everything and anything that is possible to rip off the creditors and try to kind of create a scenario where they would force the creditors to settle for very, very less as compared to what was actually due to them. So this was BFR. By December 2004, only 8% of the BFR cases were actually revived. 24% were recommended for winding up. By 2007, BFR had registered 5,471 cumulative references, and 1,337 were recommended for winding up, and only 825 revival schemes were sanctioned. So during all these years, during these 4.3 years when SICA or BFR was active, the World Bank doing business ratings were kind of decimal for the country. So this forum, of course, was finally eradicated by Iradi Committee report, which kind of cried for reforms in this space. And a lot of banks, a lot of creditors actually voiced out their opinion against this regime. So what is different between BFR and IBC? One, BFR was only limited to companies. IBC is a larger change that we are still seeing evolve, because it is not only limited to companies or CRP, it also has law for individual insolvency, for non-companies. But we will, of course, see that evolve once we have more infrastructure available and more acceptability to the idea of insolvency in the country. Second, of course, is that the biggest change here has been the debtor in possession versus the creditor in possession, or the idea that an individual or independent professional is at the helm of affairs. He has to follow the rule, follow the code, follow the regulations, and that resolution professional that we have created now is that independent authority, which is a private entity, is an individual entity who again does this for the purpose of with speed in his mind, and he has that efficiency with him, has those stakes involved which allow that insolvency professional to function, which was, I believe, totally absent in the earlier regime. Of course, we had BIFR as the regime at that point in time, which were the members or the decision makers. We have NCLT today. But when Dr. Sahu, the first chairperson of IBBI, talks about 4 pillars, 2 other pillars that he talks about is one, the IU. Now, even when IBC is talked about, very few people talk about IU. But IU in itself is a very, very, I would say, drastic and a very, very good reform, or a very, very good idea, which is not understood to be available anywhere else in the world. And that's another pillar which is again evolving, and it has further evolved with the recent amendments, where IU entry is something that has become compulsory now before somebody files a case in NCLT. So even for OCs, so that's again something which will evolve over time. And of course, the 4th pillar that he talks about is IBBI, or the regulator itself. So again, where insolvency professionals require regulation, I believe IBBI has done a great job in making sure that the code and the regulations are followed in law and in spirit and in practice. And we see that this has been a regulator which has been the most proactive amongst the regulators that we see in India.
So, Ankit, see, you're absolutely right. When the critics are saying that the IBC process is too long, critics are also saying that the recovery under IBC is much lesser. But then the figures, in fact, and see, let us understand what we have now and what we used to have earlier. We have seen 29 years of BIFR. And in this 29 years of BIFR, and when we see the outcome, now the outcome, if I compare the outcome, as per the MCA's own press release, the 4 lakh crore has actually been recovered by Indian institutions under IBC. 4 lakh crore has been recovered. And the gross NPA of all the banking sector, it used to be 11.8% in 2017. It has reduced to 2.1% in 2025. Now, this drastic improvement in gross NPA, this actually has improved the health of Indian banking industry, complete banking industry. In case we go back to 2016-17, all PSUs in fact were under loss, many of them, and taken together, it was overall it was a loss to the exchequer. And if we see the latest financial year, the exchequer has made about 1.98 lakh crore from public sector banks. How it has happened? See, it has happened because of all these earlier schemes, like winding up is under IBC, the CDR is under IBC, SDR is under IBC. So presently, in case there is any case which actually wrong, where there is a default, it is only two options. One IBC and the other is SARFAESI. Of course, the banks are also trying some kind of restructuring or some kind of one-time settlements, but those things are also now coming under IBC because of the new framework which is coming to India through this IBC Amendment Act 2026, that is CIIRP, Creditors Initiated Insolvency Resolution Process. In that process, again, we will go back to debtor in possession, but that would be a kind of a hybrid model. Like we have seen BIFR, where it was complete debtor in possession, and we have seen 29 years, it did not give results. And then we have seen the IBC, where the complete creditor in possession, and we have seen some criticism. So therefore, now there is a hybrid framework. That is, the COC will have the power, the resolution plan a resolution professional will be appointed, and the business will be conducted by the promoters. However, under all those restrictions which the COC may impose, as per the requirement from case to case basis. So once we see all this recovery, 52.4% of the total recovery has gone to banks, and the IBC recovery rate is 36.6%. Now, we also we are not even, in case we actually compare the recovery rate with the liquidation value of these companies, then it is 167%. And now, see, all these cases that we've dealt with, these are all legacy cases. Something was NPA in 2010, something was NPA in 1999. So all those old NPA, when we file claim, all the interest, compounded interest, penal interest, all this is added to the total debt. And then debt becomes 5 times, 10 times in some cases, whereas the asset value remains the same. Because in case there is a machinery, there is a business, there is a building, so all this will get depreciated. And the interest and the compound interest and the penal interest is getting added. So as compared to the liquidation value of the companies, the realization has been 167% of the value. Like in case, that is through the resolution processes. And even in liquidation also, the liquidators have recovered much more than the liquidation value through a very, very transparent auction process. So all this is achievement. And the critics, of course, when the critics talks about that this slow, and then actually we should see what happened in BIFR, SICA, when it used to take like years. It used to take 15 years. 10 to 15 years it used to take. And then also it was not possible whether the resolution will be found or not. And in case we talk about liquidation, we have to compare this liquidation process with winding up process. Now, let us understand the winding up process under the Companies Act, because there was no other exit route. And once you form a company, it has to go through a winding up. Otherwise, there was other shortcuts. Those shortcuts were not, in fact, 100% closure. The 100% closure of a company is only through winding up. All others were basically how to strike off your name from the register of the maintained by registrar of companies, so that you are not supposed to file various compliances. Now, the 6,259 companies in liquidation proceedings, like in March 2005, and it was all with various high courts. And the time, in fact, was taken for all these winding ups were, in fact, between average was about 11 years. And in fact, it had gone up to 25 years also in some cases. And so therefore, this was also a very tardy process. So any person who actually wants to exit business, which is his fundamental right as per the Constitution of India, was not able to exit the business. Once a defaulter will always be a defaulter. That was the time that we have seen before IBC. Now, as a businessman, I have a right to exit. And if my business have failed, the creditors will take it very happily, because whatever is remaining in the business, they will share. The promoter, in case he has not ended up into fraudulent activities, he will be he will be free from that business. And in case he is not a kind of accused out of for any kind of the fraudulent or unlawful trading, then he would be immediately, he can start his own business once this business is closed. Similarly, for a personal insolvency which is yet to be implemented, it is a fresh start. If you have defaulted, if your business have failed, and you have not ended up into fraudulent transactions, then you actually will get fresh start within 1 year of the bankruptcy process. So this was not available earlier. The people were not starting businesses. Foreign companies were not coming to India for starting business. They were not floating their own companies in India because it was very difficult for them to close thereafter. It was very difficult for them to close and winding up the businesses in India. So this is where we actually have to see why the critics are saying that the IBC is slow and the IBC recovery is lesser and it is time consuming. So in case we have to compare with the past, we are much better. We also agree that there are still scope for improvement, and we understand. When we saw the celebrations are going on, even the government representatives, the lawmakers also assured that yes, whatever the shortcomings had been, that would be seen. Whatever we have seen, that is a transitional period. We transited from the BIFR and we transited from the winding up processes to IBC, and now we will see the growth, and then we will become the international icon that yes, India actually has implemented IBC in a perfect manner. So this is what is the Ankit one criticism. I think we can actually move on to the other scenarios, like the kind of a new kind of a structure that India in fact brought, that is the resolution professionals, the insolvency professional entity, insolvency professionals, then the insolvency professional agency, information utility. So these are the institutions and the registered valuers. So these are something which has been created by the IBC. And Ankit, in case you can brief about it, why do you think that it is a matter of celebration that in the last 10 years, this kind of structure was made and it is continuing successfully? And this is the first time in the history that the private professionals were given so much of responsibility. And it is continuing, barring a couple of incidences, which is possible everywhere. You go to any profession, there will be 1%, there will be 0.5% people who actually will spoil the image of the profession. May it be medical profession, may it be engineering, may it be teaching, may it be the law profession, and may it be even the bureaucrats or politicians. Not like if it is only 0.5%, in case we see out of the total insolvency professionals, how many has been accused of any wrongdoing? The numbers are even less than 0.5%. So that is also a kind of achievement. For the first time, a individually professional, he has been given powers to sign check of about 40,000 crores. And that is the achievement. That is the matter to actually be celebrated. So I think this is what you should touch base. How much has actually been what is the size of this infrastructure that I spoke?
So, of course, we kind of understand the insolvency professional idea and how in the initial period, for those people who started early in this profession would remember that the first few professionals were registered simply based on a certain experience as profession in profession. And after that, they were also required to give an examination. Now, this entry barrier of the examination for insolvency is something that everyone talks about. Anyone who is actually an insolvency professional today carries with him a lot of pride that they were able to pass this examination. So in case you look at statistics given by Insolvency and Bankruptcy Board of India in their March 2026 newsletter, you have 33,200 attempts that were given for this examination, out of which 5,838 were successful attempts. So look at this rate. Similarly, in case we talk about valuation professionals, there again we have a very, very similar number where we say that valuation examinations, the total number of attempts that were given by various people were about 50, number of attempts are about 60,000, whereas the total number of professionals there are again about 6,000. So this establishes the rigidness of the entry barrier and how the insolvency professionals who have been allowed to take this responsibility are the ones who can understand this complex law and pass this examination. That's one entry barrier. The second is, of course, that when we talk about numbers, we say that we have 4,527 registered insolvency professionals today, out of which 1,900 have an AFA. That means 1,900 are practicing professionals amongst these registered professionals. So these are, for the number of cases that we have every year, we have about 600 cases which got admitted in 25-26. For those 600 new cases, look at the infrastructure which is available or the insolvency professionals which are available to take care of those cases. We then have 3 IPAs, which are all created by the 3 institutions which are, of course, very old in the country: Institution of Cost Accountants, Chartered Accountants, and, of course, company secretaries. We have about 120 plus IPEs now. So again, when we talk about larger entities which are working in the insolvency space, we have 120 large firms which are taking care of these cases. 55 plus IPEs are registered as IPs with IBBI. We again have registered valuers, about 6,000, more than 6,000 registered valuers are there. And that's again a framework which has been developed by IBBI, and therefore we say that it is a success of IBC, because if IBC would not have been there, the need and the requirement to reform and acknowledge, or rather register, a fresh breed of registered valuers would not have arisen, because we had that need, and the IBBI and everyone's understood the importance of valuation in this IBC process. This was, of course, done. And now, as we know, the Companies Amendment Act, which is yet to be passed by the Parliament, it proposes to modify and say that IBBI itself will be the valuation authority under the Companies Act. So that is what is the change now, that IBBI will function as the valuation authority under Companies Act as per the change proposed in that amendment. Although practically, for all purposes, IBBI is already doing that, but it will further acknowledge and make this ecosystem available for other government requirements.
So that means, Ankit, see, like 2 new professions have been created by this IBC and IBBI: insolvency professionals and the registered valuers. And these 2 professions, which were not there pre-IBC, and actually registered valuers would be used for various other purposes also, whereas for the insolvency professionals, they would limit themselves into insolvency space only.
I will add more. We have IU, which is again a creation of this code. Then we have 3 IPAs. Now these IPAs are not only registering members, they are conducting widespread education with respect to the insolvency law, which is not only used by the insolvency professionals, but also by lawyers, also by everyone who is part of this ecosystem in any indirect way also. It is also, passing on that knowledge to companies as to how to structure their business to avoid the bad influence of insolvency in any possible way for them. So that is also something which the ecosystem expands to. And then we talk about 14 RVOs. They are again managing registered valuers. So it's a very large ecosystem. Even if we talk about NCLT, now we have 63 sanctioned members that we had in Companies Act. They are also, I believe, spending about 80-90% of their time on insolvency related matters as compared to what they were doing under Companies Act.
But this is something which needs a little enhancement in the capacity and the infrastructure. That is one of the criticism which actually I would not say that there is a reason to counter those critics. But yes, this is something that the government has assured that they are coming up with the more benches, more members, and that issue also would be resolved. Not only this, whatever the government has done in the last 10 years, that also assures us that this particular problem of infrastructure with NCLT, NCL80, and the number of members and the capacity, that also would be resolved, because the government has done a lot in the past. Now, if we understand that the government, in fact, in the last 10 years, the government has actually brought 7 amendments duly approved by the Parliament of India. And then this particular code, it was a full complete code, and in case the powers with Insolvency and Bankruptcy Board of India, the IBPI has actually brought in more than 100 regulations. First of all, regulations for each process. Then there were amendments whenever there is any feedback, the amendments. Whenever any difficulty is faced, amendment. And there are circulars which actually for the purpose of guidance of the stakeholders, the insolvency professionals, the registered valuers. So 100 plus. So that means it's for like in case we see 100 plus means 10 amendments in a year. That's too much. That's something. And this is what the government has already done. And therefore, we also feel that this also will be done because the need has actually been seen. And now the critics are saying again and again that the capacity issue and the delay is only because of the capacity constraint and the infrastructure constraint. And that matter has gone to government. The government actually is working on it. This is what we believe. When we see the other part, how the education has actually been spread about insolvency law, how many portals have actually been developed, how many books has been created, how many people are working only for spreading education about IBC. I think you can touch base this particular issue. What all has actually been done so far, or like as far as this spreading education, and there are various seminars, various webinars, various public meetings, various feedback meetings has happened in the past. So this is one law where the regulator and the central government, they are actually very, very proactive in taking feedback. Now, in case we see the digital infrastructure about spreading education, in case we see the various courses which are being conducted by all the three IPAs for the continuous education of the stakeholders, the CPERs regulations which are mandatory for the professionals to continue studying and obtain the CPERs. So when we see this, in fact, the knowledge, the legal data is available. So there are kind of popular public domains where we can actually subscribe and we can get all the information about law regarding judgments. Then this IBBI various publications that has come. The various publications has actually been published by the Institute of Company Secretary, the IPA of the ICSI, and some books are also published by the IPA of Institute of Chartered Accountants of India. So there are, see, what I understand, there are more than 800 books that have already been published. More than 800 books in this 10 years of law has already been published. I'm not saying the journals which are coming regularly. Insol India has also published various studies, and there are various academic research which has actually been undertaken by various MBA institutions. So all this when we see, so it is basically impacting the Indian business, Indian economy, that we actually could see in the ease of doing business index as set up, as in fact the data was being collected by World Bank. Now it has actually, the World Bank has actually closed this process in 2020. So when we see in 2017, India was ranked at 130th, and now in 2020, India overall rank was 63rd, and resolving insolvency rank was 52, and it actually came down from 136. So this also gave a kind of international recognition that the India has implemented insolvency law. So that actually that has also impacted. That has also impacted the foreign investment to come to India, as they have found ease of doing business in India, because ease of doing business for them also, in case we will fail, will come back. So that actually IBC assured them, yes, you would be able to go back to your own country in case you fail. So they came back, and that actually improved the ease of doing business. Of course, the World Bank didn't carry this index after 2020, but very recently the World Bank have started a new index that is a business ready index. Be ready also, business ready index, and India is yet to participate into that information survey. And I think whenever this new survey will come based on the new parameters, we feel that the insolvency law would be a big impact on this index. So, Ankit, what you would like to add on this?
I think it's
the government's role and the various educational processes.
I believe the journals that we have from the three IPAs, and also the quality that we have with respect to the various CPE or CEP sessions that these IPAs conduct, it's remarkable. And there are so many professionals who kind of share their experiences. In case I talk about the whole process of inducting, or rather insolvency professionals to get registered, the idea that there is a full 50-hour training, practical training by experienced insolvency professionals rendered to newly registered insolvency professionals, that itself kind of shows how this is a remarkable exchange of information between various professionals. Also, I believe any insolvency case that comes to any IPs is mostly a collaboration of sharing knowledge between the insolvency professional, the IPE partners, the COC members, and the rather even I would say the promoters, even the SRA. Every process for passing a resolution plan would involve multiple rounds of discussion and knowledge sharing of how ideas, knowledge sharing of ideas, exchange of ideas to enhance the resolution value for that company. I think that happens in every company, and that is remarkable about insolvency, that an insolvency professional might be exposed to multiple industries, but at the same time, at the core, he has to take care of the basic understanding, the basic processes of how insolvency should cure the whole problem. And we see increasingly that the management of going concern operations has become much easier as compared to what I believe it was in 2016. Now, today, the know-how that is available to insolvency professionals and IPEs as to how to manage and how to take care of the going concern operations of a CD is remarkably transformed as compared to maybe the first few months as to when this insolvency law came into being, when everyone was having difficulty in even taking custody and control of all the assets of the CD.
In the last two events that I attended, I also saw that some of the critics were saying that the creditors are not trusting the IBC because the number of applications being filed from year on year has reduced. So the numbers, in fact, was saying there was a peak of about 2,000 applications in 1 year, and that was in 2019-20, and then it has actually reduced to 720 applications during the year 2024-25. So it was also said by some of the critics that the insolvency and bankruptcy law is no more trusted by the creditors. Now, let us understand when this law started. At that time, all those cases which were pending before BIFR and all those winding up petitions which were pending before High Court, in fact, was transferred to the IBC. And then there were many other cases which were in fact under the CDR, STR, and the banks were not finding their way to come out. So those are also brought in the first few years. Now, the overall thinking of a businessman has changed. Overall thinking of a borrower has changed. Now the borrowers are borrowing with a clear vision that they would be able to repay because they don't want to default. They understand it very well that in case they would default, this business will be taken over by somebody else and we would be out of the business. And rather, we would also be kind of accused for various wrongful transactions. So therefore, the thinking of a businessman actually has changed only because of the insolvency law. They only borrow if they can pay. So therefore, like if the applications are reducing, that doesn't mean that this IBC's failure. It actually means that the IBC has done its role. Because see, when this started, it was said by Dr. M.S. Sahu, who was the first chairman of IBBI, that the best use of IBC would be not to use it. That only by having a law is more important than implementing that law. In fact, by using that law. In fact, we have a law in India that any use of the drug is prohibited, and if there is no accused for the next last 2 years, that actually means that law has worked. That law has played its role, because there is nobody who is non-compliant now. So this is also, the critics are saying that the law it is not being trusted anymore. Yes, I believe in between, the creditors in fact started shifting to one-time settlement and various kind of restructuring schemes that they've started within their own banks, only because of the delay in IBC process, which actually is coming to a kind of there is a sea change which has actually been brought to this IBC by IBC Amendment Act 2026. The new framework, which is creditors initiated insolvency resolution process, in fact will reduce all the one-time settlements and the restructuring, because see, there will be no delay. Whenever the creditor will opt to start CIRP, they can opt while sitting in their own room. They can just give a notice and the RP can be appointed. So that is what is the change. Ultimately, what is important? One, that if there is a problem, the government should identify that. After the identification, the government should resolve that or try to resolve that. That's what is being done. And in the meantime, the NCLT capacity is also being increased. So this criticism that the creditors are not trusting, this is also not correct.
Yes, I think we should understand that the whole framework of committee of creditors is something that sometimes we take it for granted. But look at the beauty of how whenever a company or a corporate debtor would have a multiple banking with multiple institutions or have multiple stakeholders, how that committee of creditors comes together and jointly works on resolving the company's issue. Now, in case we talk about any such other mechanisms which have ever been designed for the creditors to jointly work, I can't remember or recall any framework which offers a better and a more transparent approach for creditors to work together to resolving the company as compared to what IBC offers. Before this, we had various other regimes which were suggested by RBI, but all of them lacked the incentive and the power for the committee of creditors to work together. Today, the committee of creditors has to work together to take a decision on the resolution plan, because they understand that if there is value in the going concern, then implementing a resolution plan or approving a resolution plan is most important to preserve the value of the corporate debtor as compared to taking it into liquidation. And therefore, they work hard in making sure that a company where resolution can happen does not go into liquidation, protecting not only the company, not only its business model, but also its employees, also its workmen, and maybe sometimes where the promoters are coming with clean hands, even the promoters' rights over the company.
I think, Ankit, you are right. See, I also saw some people criticizing this IBC, saying that the promoters are losing their companies unfairly. I just want to understand what happened when for the last 29 years the promoters were in fact enjoyed their companies unfairly, when they didn't pay a single paisa to their creditor, but they were still enjoying the benefits of the company. 29 years of BIFR, and then various other people, they actually have gone through CDR and SDR and S4A for decades, and they actually, the banks were not having any option except the promoters. They were continuing with the business, they were fleecing the company, and finally the bankers were in fact losing. Now, even now in the case of MSME, if a promoter is genuinely interested in taking the company back, he can still take it, and he can still take it with a clean slate. That option is still available. But then promoter must be ready to take it over. Now, he must not be involved into all these fraudulent transactions. He can still take away. And now with this CIIRP, the promoters will be able to retain the company, and promoters will be able to get the clean slate also. So this criticism that the promoters were losing their companies unfairly, that is also not Ankit well.
No, I do not agree with it at all. I think if we talk about company getting in default and the promoters, we can't say that any promoter has lost their company unfairly. I would rather say that the promoters have lost their companies. Maybe some of them were caught off guard by the idea that a law can come, and suddenly their negotiation power to kind of deal with the bank will get diminished. But wherever they have promoters go with clean hands to the bank and seek restructuring, seek assignment to a ARC, or seek some kind of an option available based on the asset value which is there in the company, then I think they get that restructuring done. And wherever the banks are supposed to lose money, I believe in a country like ours, where majority or many of the funds that are given by banks to these corporate debtors are public money, it becomes very difficult for the government or the banks or to anyone to say that, okay, we will give the same company back to the same promoter at a haircut. Yeah. So that is where the social idea and the public money concept comes into, which might be absent internationally. But in India, I believe it is still very, very important, because you can't give back, or rather just kind of give a haircut to the banks and kind of keep the company or keep the assets to yourself. That is the statement today that we have through this code, and that's why every promoter would actually take debt and use debt very carefully and to the extent of what they can manage in their company.
Ankit, I agree with you, and also I saw the criticism. In fact, this criticism is for the last 10 years. I have seen that there are many stakeholders. They are saying that the IBC is not good for operational creditor. IBC is not good for small creditors. So I want to understand how it is not good for operational creditor. I want to understand these 30,000 cases which actually has been pre-CIRP resolution for 30,000 cases, and most of this was applications under Section 9. So that means most of those operational creditors, they submitted their application and the company came forward and settled the dues. Now let us understand what was the option available before IBC. If I am a supplier and I first I supply my goods and then I go to the customer and beg for my payment. And also I try to develop the social relationship with them. I visit on Diwali, I visit on Holi. So basically to understand and kind of a social pressure to get your money back. But now, as an operational creditor, you actually can take your legal rights. There is no need to beg for the money which is your rightful money. So that is also a not a, and otherwise also when we see that there is one is a financial creditor who has given 1,000 crore to set up a project. The other is a bank who has given 1,000 crore to actually get a working capital for this project. And the other person who is an operational creditor, he has one business cycle. He has actually contracted with the company to supply material, maybe 10 lakhs of rupees material or maybe 1 crore of rupees material, and the payment terms are that he will kind of get the money in say 30 days or 60 days. Now, in case he is not getting the payment within 60 days, he can stop the payment. He can stop the supply. So, in case he is continuously supplying the material despite no payment being received, that is the risk that he is taking and he is liable for that. Otherwise, the risk of an operational creditor is only limited to one business cycle, means supply and get the payment. In case he is not getting the payment, he can go to the NCLT now and he can get it settled. So this is also not true that it is not good for operational creditor. Ankit, some critics are also saying that the NCLT, the work is very slow. Now, let us understand in the last 10 years, 30,000 applications actually has been resolved pre-CIRP. There are about 9,000 CIRP cases, and then there are 3,000 liquidation cases. Now, let us understand 30,000 plus 9,000, 39,000. First of all, let me say that the NCLT was, in fact, originally the NCLT was constituted under the Companies Act only to look after the company law cases. And the 63 was the total bench strength, and that is still continuing, whereas the additional responsibility of adjudicating authority came to NCLT. And now the number of cases only from insolvency law is 30,000 plus 9,000, 39,000. And in case you can, on an average, in case we consider 5 applications in each case and 10 hearings on an average, or 5 hearings on an average, how much it becomes, Ankit? Can we? So if you see the number of orders that might have been passed by NCLT members in the last 10 years, that is a very, very large number of orders. So they are also human and they are passing orders in such huge volume. I think we have to say some good about them also. No? So we need to say that they have done their part to the best of their capacity, to the best of their ability. So the criticism is not on the members presently sitting there or who had actually worked in NCLT. The criticism is only on the capacity. The capacity should be more. However, the present and the past members, they have worked very hard if we look into the number of applications. Whenever a new law is promulgated, it takes time in settling down. It is very difficult to make a law which is perceiving all kind of situations and eventualities. When different situations and eventualities come in practice, accordingly the amendments are also taken place and accordingly the regulations are also made. In this particular case, there were some difficulties within the basic law which has been resolved now. Now, for example, the provident fund of the employees and the gratuity of the employees were not protected. Therefore, the Supreme Court, in fact, protected this, which actually created a lot of litigation. The distribution of proceeds amongst the creditors, and that was also having a flaw. And it was not clear whether while distributing, the liquidator will consider the value of security and the priority of charge of each creditor. That has actually been clarified in Amendment Act 2026. Similarly, whether this income tax or statutory tax, they would have any kind of priority or not, that was also not there in the law. So they were basically different judgments from different authorities or forums or courts. That also created a huge kind of litigation. The rights of different creditors, secured, unsecured, operational, other, that was also not settled. So any new law, this happens, and this has happened. So that's the reason that we have seen the transition. Now it is the time that we have to see the growth and finally the complete settled IBC law of India, including the institutions that has actually been developed under this law. What we foresee that India will finally become Indian IBC would become a global law. It will have cross-border, it will have group insolvency, and it will also have the individual insolvency, so that every person should actually have a right to exit and to have a re-life for business. So this is all from us regarding the why we are celebrating 10 years of IBC. So we have given all the reasons of celebrations despite criticism. Thank you very much.
Thank you.